Respondents were not unfairly surprised by FDA's denials. They now claim that they had no idea they needed to compare their flavored products with tobacco-flavored e-cigarettes, but their applications drew such a comparison. They just did not have sufficient scientific evidence to bear out their claim that non-tobacco flavors are, quote, crucial to getting adult smokers to make the switch, end quote. Nor did respondents suffer any prejudice from FDA's failure to look at their marketing plans. They've identified no features that FDA has not already found are insufficient to mitigate the heightened risk of youth uptake that flavored e-cigarettes pose, making the Fifth Circuit's remand to FDA a useless formality. This court should reverse the Fifth Circuit's outlier decision. I welcome the court's questions.
Well, in fairness to respondents, I think their argument is that the guidance were actually a moving target, that either they weren't clear or you changed the guidance as time went on.
That is their argument, Justice Thomas, but I think that the key point is that they knew from the statute that they needed to be making this comparison about what the benefits were with respect to existing smokers and weighing that against the potential costs with respect to non-smokers and attracting youth. They knew throughout that FDA was concerned about the fact that flavors are attractive to youth, and that's the second column that was going to be problematic. They knew then, therefore, that if that was a heightened risk on that side, that they needed to show a heightened benefit on the other side. And as I said in my introduction, their applications acknowledged that they were trying to make this claim. This is clear. If you look at their application, they say when they're considering the question of evaluating the role of flavors with respect to population health incomes, this is their application. Relevant questions include the impact of flavors on adult smokers who transition or not to e-cigarettes. That's at page 355 of the Joint Appendix for Triton's application. The same thing is on page 448 for Vaptasia's application. So they were trying to make this argument, and they said that the research is in its infancy, but their own review of the scientific literature said that no conclusions can be drawn about the association of e-cigarette flavors and smoking cessation. And so the data just weren't there when they were filing their application in 2020.
Do you recognize an obligation to tell people what they have to do to comply with your regulation, or do you think it's simply an obligation not to mislead?
Well, we think that in this context, the statute gave them the basic calculus that FDA was going to apply. FDA did